I was catching up with an old friend, a solicitor who works in family law in the UK. She had this look on her face, just completely worn down. She was handling a case for a woman seeking a divorce, citing grounds that were straightforward under British law. Should have been simple. But it wasn't. The woman's community, she explained, also had its own informal council, a Sharia tribunal, and that tribunal had already issued its own judgment, that the marriage was valid and the woman had no right to leave. So my friend was stuck in this absurd legal twilight zone. In one hand, she had the entire framework of UK law, built on individual rights and equality. In the other, her client was completely bound by a parallel system, a system that the liberal state, in its quest for tolerance and multiculturalism, effectively allows to exist. My friend just shook her head and said, the law is supposed to be universal, but what do you do when it's not? What do you do when the very tolerance we champion creates a pocket where our own laws don't apply? That conversation stuck with me. It's the perfect snapshot of a deep structural paradox. It's what happens when the universal idea of liberalism crashes directly into the particular, and a system designed to include everyone suddenly finds itself unable to protect everyone. So yeah, that story is really our jumping off point today. Our mission for this deep dive, essentially, is to unpack this very paradox. We need to get into the core conflict here.
Right.
We'll be examining, the hidden cultural origins of Western Universalism, because it didn't just appear out of thin air, and contrasting that with other competing civilizational frameworks, because let's face it, liberalism isn't the only game in town claiming universality.
Not at all.
And then finally, we really have to analyze those direct policy collision points within modern democracies where these different systems actually clash. We'll use that UK dilemma my friend faced as a sort of case study.
Yeah, and it's such an essential clarification to make right at the start, because if you really strip away all the political noise, the bedrock premise of modern liberalism is this incredibly bold idea that things like rights, autonomy, dignity, equality, they're universally valid.
All right, they just are.
They just are. They aren't things you earn. They're not privileges granted by a king or a state. They're general rights that, well, they arise simply from being human.
From being part of the human race.
Exactly. This idea of inherent, intrinsic, and crucially equal dignity. That's what gives things like human rights law, international conventions, even just our basic expectations of how people should be treated, their moral weight, their authority.
I think most people, certainly in the West, just assume that this idea that everyone has equal dignity, well, it comes from simple, rational thought.
Yeah.
Logic. A purely philosophical achievement of the Enlightenment, maybe?
That's the common narrative, yeah.
But here's the challenge our research really throws up. What if Western Universalism is absolutely not some kind of neutral inheritance of pure reason? What if actually it's the product of very specific Judeo-Christian theological traditions?
Okay, hold on. I just want to pause on that because, that's a pretty controversial claim, right? Especially for secular historians or political theorists. Are we suggesting that concepts like inherent rights can't be derived just from Enlightenment reason, that they have to come from theology?
Well, that's precisely the argument that historians like Tom Holland are making. His view, and others working in this area, it's basically that modern secular values, equality, compassion for the vulnerable, the idea that just an ordinary person has intrinsic worth.
Things we take for granted now.
Exactly. Things we take for granted. He argues they're fundamentally the afterlife of Christian theology.
Yeah.
These weren't the dominant values in, say, the Roman or Greek ancient world. Not at all. They required a kind of specific moral mutation, you could say.
A mutation. Interesting way to put it. And that mutation, following this line of argument, comes specifically from that sort of leveling doctrine you find in early Christianity.
Yeah, particularly Paul's letter to the Galatians, where he says there is neither Jew nor Greek, slave nor free, male nor female, for you are all one in Christ Jesus, which was revolutionary at the time. Before that, the ancient world, it just routinely categorized people by their status, their utility, their origins. There wasn't this universal oneness.
Okay, so if that leveling doctrine kind of prepared the moral ground, then the theological cornerstone, the thing that actually built the concept of universal value, that must be the belief that humans are created in the divine image, the imago Dei.
Exactly. That's the absolute core of it. This belief, it establishes intrinsic, inviolable, and fundamentally absolute worth for every single person.
Yeah.
Doesn't matter what their station in life is, doesn't matter how useful they are to society.
Right. The moment you're conceived as being created in that divine image, you get this absolute value attached. And that's a really profound philosophical jump, isn't it? It means A human being is not valued for what society can get out of them.
They're not just a means to an end.
No. Their worth is intrinsic, it's non-negotiable, it comes before politics or society even enters the picture, it's pre-political.
And then this idea of supreme universal value was sort of supercharged, wasn't it, by the New Testament concept of redemption?
Yeah, the idea that grace, through Christ, restores that divine image which, the theology says sin had blurred or damaged. But the value itself remains universal because its anchor is spiritual. It precedes all those social, political, or economic differences we create later.
And we can actually trace the ripple effects of this core concept directly into modern law, contemporary legislation.
Oh, absolutely. Think about the legal wrestling over the right to life. Article 2 of the European Convention on Human Rights, the ECHR, it guarantees the right to life. But the European Court of Human Rights has consistently, time and again, ruled that this right does not automatically include a right to die, like through assisted suicide.
Which is a stance, it's deeply shaped by the historical Christian view, isn't it? The condemnation of suicide as, self-murder, rejecting the divine gift of life.
Definitely. There's often this encouragement within that tradition to endure suffering, perhaps as a spiritual path, rather than seek to end it autonomously.
It's a clear clash, isn't it? The idea of the sanctity of life, even amidst terrible suffering, it overrides the kind of modern and liberal push for complete personal autonomy, even over death.
It really highlights the tension. And furthermore, that original leveling idea we mentioned, neither Jew nor Greek.
All one in Christ.
That common brotherhood idea, it flows directly into non-discrimination laws. It underpins things like Article 14 of the ECHR, Article 2 of the ICCPR. The DNA is right there.
So this historical and philosophical backdrop, it was actually really critical, wasn't it, in shaping the Universal Declaration of Human Rights, the UDHR, 75 years ago. It wasn't just a bunch of secular lawyers in a room.
Not at all. It's often understated, but Christian thinkers played a really pivotal role.
Right.
And the tension within the UDHR drafting process itself, it perfectly mirrors this whole particular versus universal problem we're discussing. You had people like Jacques Maritain, the French neo-Thomist philosopher.
Right.
He was grappling with this huge problem after World War II.
Yeah.
How do you get opposing, deeply entrenched ideologies, communists, secular humanists, religious conservatives, how do you get them to agree on anything fundamental?
An almost impossible task, you'd think.
Right. And he landed on this very pragmatic approach. He basically said, look, agreement on the list of rights might be possible, but only, and this is his famous quote, on condition no one asks us why.
Huh. Okay, so agree on the what, but not the why.
Exactly. He pushed for pragmatic agreement on the practical conclusions the actual rights listed, while deliberately separating the ontology, the question of the ultimate objective foundation for human nature, from the epistemology, which is the different cultural ways societies might arrive at understanding those rights.
That's quite radical, actually, sort of sidestepping the biggest philosophical fight.
It was radical pragmatism for its time. Maritain essentially accepted that getting everyone to agree on the theory of human nature might be impossible, but practical cooperation on defending basic dignity, that was achievable. It let them avoid getting bogged down in whether rights are God-given or naturally endowed or just socially constructed.
Okay, and then alongside Maritain, you had Charles Melick, the Lebanese ambassador.
Yes. Malik chaired the Human Rights Commission, and he was instrumental in providing what you might call the spiritual guardrails. He argued incredibly strongly for Article 18, the freedom of religion and conscience.
Right. Why was that so crucial for him?
Well, he was adamant that the UDHR couldn't just be about material stuff like food or housing. Having seen totalitarianism up close, he'd actually studied under Heidegger in Nazi Germany before fleeing.
Wow.
Malik was acutely aware of systems designed to just crush personal thought, personal belief. He argued human rights must protect a person's mind and spirit.
It stopped the state controlling the inner life.
Precisely. To prevent systems like communism or any other totalizing ideology from extinguishing what he called the free, separate personal life. For Malik, human dignity absolutely required the freedom to think, to choose, even, he said, to rebel against his own society, or indeed against the whole world if it is in the wrong. That was the ultimate defense of the individual conscience, totally inviolable.
It's just amazing when you trace it back, how these theological ideas really fueled early advocacy against social evils that were just accepted back then, part of the normal fabric of society.
Yeah, we're talking late antiquity here, 4th to 6th centuries. pushing way beyond Greek and Roman thinking, which, as our sources point out, really lacked the concept of human dignity in the way we understand it today.
And the prime example has to be slavery, right?
Yeah, absolutely.
Yeah.
Slavery was everywhere. It was deeply embedded in Roman law, the economy. Even the Bible itself didn't immediately ban owning slaves outright.
Right.
So when you understand that context, Gregory of Nyssa's sermon in the 4th century, it's genuinely a breathtaking departure. He wasn't just saying, be nicer to your slaves. He attacked slavery as an institution, the whole chattel principle.
The idea of owning another person like property.
Exactly. He framed it almost as like cosmic arrogance, divine rebellion. He raged against it, asking, how dare a mere mortal man who's temporary himself put a man-made price on another rational being created in God's image, buying and selling him like an animal?
That fundamental question. Who is entitled to buy and sell the human being?
It was revolutionary because it struck at the heart of Roman legal structures that treated the slave as an object, a res, just transferable property. This Christian conviction, it laid the ethical foundation centuries later for the abolitionist movements. The argument was that treating people as property was fundamentally sinful, arrogant.
So this whole historical line brings us to a really critical warning, doesn't it? The idea of the cut flower concept.
Yeah. The argument is, if the civilizational soil, the theological context that nurtured these concepts, justice, dignity, universal rights, if that fades away, if we forget it,
the concepts themselves might just wither, like cut flowers without water.
They might wither, or worse. If you take those concepts and transplant them without their organic roots into a totally different cultural or political environment, the result could actually be dangerous, produce a kind of poisonous toxin.
Oh, so what's the danger?
The concern is that if you keep the form of human rights, the laws, the declarations, but you lose the underlying substance, the theological or philosophical justification for absolute dignity.
Then the concept becomes weak, negotiable.
Exactly. It loses its inviolability. It becomes something that can be balanced against other things, maybe utility or state interests or cultural norms. It's no longer absolute.
Okay, that sets the stage perfectly for the next big challenge. What happens when this rights-based universalism, which we've just traced to its specific roots, bumps up against a really deeply entrenched system that's based on a completely different premise?
Right.
So let's shift gears now, quite dramatically, actually.
Yeah.
From the West's rights-focused philosophy to an Eastern duty-based framework. Let's highlight that fundamental civilizational difference.
Yeah, it's a necessary contrast. When we look towards East Asia, particularly societies historically shaped by Confucianism, China, Japan, Korea, the primary focus isn't really on the individual and their rights.
It's different.
It's fundamentally different. The focus is much more on social duties, or dharma, if you look at broader traditional Asian thought. The whole structure is built around the idea that individual rights, if they exist explicitly at all, really only rest on properly fulfilling your duties to the community.
So it's flipped. Instead of, I have a right to X.
It's more like, I have a duty Y to my family, my community, my state, and fulfilling that duty is paramount. The key concepts here are Ren and Li.
Ren and Li. Okay, what are those?
Ren is essentially complete human virtue. But it's not an abstract internal thing. It's only realized through relationships, being a good son or daughter, being loyal, being kind. Li then defines the proper conduct, the customs, the social institutions, the rituals you need to observe to maintain those relationships.
So they're linked. Good conduct stems from inner virtue.
Intrinsically linked, yes. The system relies on everyone performing their specific role within that defined social network, according to Li, motivated by Ren.
And hierarchy. Because Western liberalism tends to view hierarchy pretty suspiciously.
That's another huge difference. In the Confucian framework, hierarchy isn't automatically seen as oppression. It's actually viewed as essential for stability, for social harmony, for maintaining the collective identity. The emphasis is overwhelmingly on group orientation. The harmony of the whole is prioritized over the autonomy of the individual part.
And that must shape the political philosophy in a totally different way.
Dramatically. The ideal liberal state, it favors non-interference, negative liberty, freedom from coercion. It uses separation of powers, checks and balances, all designed to protect the individual from the state. The ultimate goal is guaranteeing individual rights.
Okay. And the Confucian state?
Well, traditionally, it prioritizes what's called the rule of virtue above the rule of law. Laws are seen as supplementary, maybe even a sign of failure. They're the stick you use for people who aren't morally developed enough.
Right.
The ideal ruler isn't just an administrator. They should be a sage, someone pursuing Ren, actively defining social relationships and promoting morality throughout society. This structure naturally pushes power towards a more unitary, centralized authority. Separation of powers can look inefficient, even potentially harmful to social cohesion.
And you can see this playing out in, say, corporate culture in Japan or South Korea, right?
Absolutely. The concept of the group, the company, the government ministry, the extended family, that's the fundamental unit of value and identity. A Japanese engineer, for instance, often defines their success and self-worth not primarily by their individual achievements or contract rights, but by their loyalty and contribution to the group.
And dissent, challenging the boss.
It's possible, of course, but it's often handled very differently, more indirectly perhaps, to avoid causing public loss of face, which would disrupt live and disturb the group harmony. Direct confrontation is generally discouraged.
There's also that fascinating methodological difference you mentioned, how liberalism uses negative principles.
Yeah, like the golden rule in its negative form. Do not do to others what you do not want them to do to you. It's about setting boundaries, defining limits on behavior to protect individual space.
Don't interfere.
Exactly. Whereas Confucianism tends to use positive principles, like to maintain others while you desire to maintain yourself, or develop others while desiring to develop yourself. It's a much more proactive relational ethic focused on reciprocal duty.
So liberalism says, essentially, you're free as long as you don't break the rules.
While Confucianism says more like, be virtuous, fulfill your duties within the relationships you're part of, and your place within the harmonious structure is secure. Freedom through belonging and duty, rather than freedom from constraint.
And this isn't just abstract philosophy, is it? There's actual data showing these different values, that Hitchcock survey.
Yes, the survey comparing East Asian and American elites on core societal values. The results were, well, stark. They really confirm that the underlying assumptions about political life are just radically different in many ways.
What were the biggest gaps?
Huge gaps. For instance, East Asians scored 71% on the importance of maintaining an orderly society. For the Americans, just 11%.
Wow. 71 versus 11. That's massive.
It shows a huge premium placed on stability, predictability, avoiding disruption, compared to the American side.
And conversely, the Americans prioritized individual metrics much more highly.
Vastly higher. Personal freedom was important to 82% of Americans, but only 32% of East Asians. Individual rights, 78% for Americans, just 29% for East Asians.
Again, those aren't small differences. They really do suggest two distinct ways of seeing the world, operating with different primary units, the individual versus the collective.
And if you unpack those numbers, the underlying political assumption seems clear. American liberalism generally views the state as a potential threat to liberty, something that needs constitutional limits.
Right, checks and balances.
Whereas traditional Confucian thought tends to view the state as the necessary moral and institutional guarantor of social harmony, requiring allegiance and participation for the system to work.
But the survey wasn't all differences, was it? Weren't there some points where they kind of agreed?
Yes, and that's important too, suggesting that globalization and shared modern challenges are having an effect. Both groups showed roughly the same level of support for certain democratic mechanisms, like using majority decision and valuing open debate.
Okay, so maybe agreement on some of the processes, even if the underlying goals or values are different.
That seems to be the case. It suggests that while the deep cultural commitment to collectivism and duty might still be very present in East Asia, they've adopted modern political procedures, the sort of shell of democracy perhaps, as a way to manage the pursuit of those collective goals in the modern world.
So we end up with these hybrid systems.
That's the idea. Maybe like a Confucian democracy, using democratic procedures but filling them with distinctly Confucian content or priorities. But the fundamental difference in the universal claim remains. One seeks freedom primarily through individual autonomy. The other seeks it primarily through harmonious belonging and the fulfillment of duty.
Okay, right. That gives us the necessary philosophical and empirical context. We've established that our Western idea of universalism has its own specific particular roots, and that other powerful, deeply rooted universalisms absolutely exist. So now we circle back to the immediate practical paradox we started with. What actually happens when one of these duty-based, particularistic legal or cultural systems operates inside the borders of a rights-based universal state?
The collision point.
The collision point. And we need to look specifically at the case of Sharia councils operating within the UK. And this really brings me back to my solicitor friend, the one I mentioned at the start. I'm thinking again about Her client, let's call her Sarah. Sarah, born in Britain, British citizen, educated here. She wanted a divorce based on cruelty. Straightforward under UK law, the civil court granted it. She was legally free.
But that wasn't the end of it for her.
Not even close.
Yeah.
In her specific community, that's civil divorce. It meant absolutely nothing. Her husband, her family, they refused to recognize it. They insisted she needed a religious divorce from their local Sharia council.
So she went.
She felt she had no choice. She ends up in this small, intimidating room facing a panel of men. And they tell her, yes, she can have the religious divorce if she gives up her financial claim on the family home and agrees to let her husband's mother raise their children.
Unbelievable. A British citizen with legal rights.
Exactly. And the British state, in its commitment to, accommodating different cultures, effectively allowed this parallel system to pressure her. For Sarah, this state tolerance felt like anything but. It felt like a trap. She had rights on paper, but she was being blackmailed because the community system, which the state tolerated, didn't recognize them.
That example just perfectly captures the crisis, doesn't it? And we have to start by getting the legal situation crystal clear. These Sharia councils, or SEs, and also Muslim arbitration tribunals, or MATs, they have absolutely zero legal status or binding authority under UK civil law. None.
But they act like they do. Or people think they do.
They act as crucial decision-making bodies, especially for Islamic divorce, and that's where the confusion and the danger really come in.
They get called courts.
Constantly. They're incorrectly referred to as courts. They're members called judges, sometimes by the media, sometimes even by the councils themselves. And this sloppy language, it fosters this really damaging public perception of a parallel legal system, and it fundamentally undermines the principle that UK law is supreme.
So why do they exist then if they're not legally binding? Why do people use them?
Because they fill a very real gap, a critical legal and, importantly, theological need that the civil system often just cannot address. The evidence is overwhelming. Over 90% of the people using them are women seeking a religious divorce.
Okay.
And the key policy failure driving this is the fact that a significant percentage of Muslim couples in the UK fail to civilly register their religious marriage, their nikah.
And if they don't do that?
If the nikah isn't registered with the state, then under English law, the woman isn't legally a spouse. She's treated as a cohabitee.
Which means?
Which means she's immediately stripped of huge civil protections. No automatic access to divorce courts for financial settlements. No claim on shared assets like pensions. No automatic inheritance rights if her husband dies. Legally, she's like a girlfriend, but religiously and culturally, she's fully married and bound.
Wow. Okay, so that's a massive vulnerability.
Huge. And even for women who do get a civil divorce, they often still need the religious divorce, the talaq, from the husband, or seeking a kula or fasq from a council for their own conscience to be accepted by their community, and critically, if they ever want to remarry within their faith.
So did the council step into that vacuum?
They step into that vacuum. But the problem is, they often apply principles and interpretations of Sharia that are fundamentally at odds with the universal principles of equality that are guaranteed by the UK state itself.
Okay, let's get specific then. What's the evidence of these discriminatory practices? The independent review flagged some of this, didn't it? Women's rights groups, too.
Yes, the evidence is well documented. Even the former Home Secretary, Theresa May, highlighted evidence of women being pressured into poverty or advised against reporting domestic abuse. The inequality is structural, starting right with the divorce process itself.
How so?
Under the classical interpretations frequently used by these councils, divorce is just starkly unequal. A husband can often issue talaq, a unilateral divorce, sometimes just by saying it 3 times.
Just like that.
In many interpretations, yes. But the wife, unless she had a very specific and quite rare clause put into her original nikah contract, she can't just declare divorce. She has to seek a divorce, a kula or fasq, from the council.
And that's harder.
Often much harder. And it frequently requires her to make major concessions just to get the husband or the council to agree. Things like giving up her mahr, the agreed dowry payment, or relinquishing claims to property, or even yielding custody of the children, basically buying her freedom.
That's shocking. And the inequality goes beyond just the divorce mechanics.
Oh, yes. The underlying principles applied often clash directly with UK equality law. In things like testimony or inheritance rules applied by some councils, a woman's testimony might be considered worth only half that of a man's. And traditional inheritance rules often prescribe that sons inherit double the share of daughters. These aren't minor points, they're direct contradictions of the principle of equal treatment under British law. And when it comes to really critical welfare issues, the outcomes can be devastating. There's evidence showing some Sharia councils have actively pressured vulnerable women to go back to or stay with their partners despite documented domestic abuse.
Pushing reconciliation over safety.
Exactly. Sometimes advising that reporting abuse to the police should only be an absolute last resort. This clearly prioritizes keeping the family unit intact, or perhaps community reputation, over the individual woman's safety and her right to protection by the state.
And what about judgments that directly contradict UK law, like on child custody?
That's another deeply troubling area. We see documented cases where council judgments dictate that child custody automatically reverts to the father at a specific preset age, often around 7 for boys, maybe 9 for girls.
Regardless of the child's actual well-being.
Regardless of the child's bond with the mother, their established life, or anything else, this flatly contradicts the absolute paramount principle in UK family law, which is always the child's best interests.
And then there are the extreme examples. Like halala.
Yes. And while we should stress this isn't representative of all councils, the practice of halala is reported as being disturbingly frequent even here in the UK. This is where, if a husband divorces his wife with a final talaq and they later want to reconcile, she's required to first marry another man, consummate that marriage, and then get divorced from him before she can remarry her original husband.
That just sounds medieval. Humiliating and open to abuse.
It adds layers of trauma and potential exploitation onto already vulnerable women.
So all this evidence together, it leads to that really strong critique, doesn't it? That the idea that using these councils as purely voluntary is, well, basically a sham.
Legally, technically, yes, attending is voluntary. No one can be compelled by UK law to go, but the reality on the ground for many women is completely different. They face immense, often paralyzing pressure from family, from the community.
Threats of being ostracized, shunned.
Absolutely. Ostracism, being labeled a bad Muslim, damaging the family's honor, and often, crucially, they simply lack awareness of their actual robust civil rights under UK law. They don't know they have alternatives or protections.
And what about when the state has intervened? Like with injunctions?
That's another shocking aspect. There are reports of civil injunctions like non-molestation orders issued by UK courts to protect women from violent ex-husbands being effectively ignored by the community or even the councils themselves. Women with legal protection orders are sometimes still brought before these councils for forced mediation or religious rulings.
Undermining the state's authority directly.
Completely circumventing it.
And there's a legal consequence too, isn't there?
Yeah.
That even if council decisions aren't binding, they can end up being sort of validated later.
Yes, that's the insidious downstream effect. Because of the time that passes and the community pressure forcing compliance, council decisions can become de facto upheld later by civil courts. For example, if a council tells a mother to hand over her children, and she does under duress, and the children then live with the father for, say, a year,
the civil court might be reluctant to disrupt things again.
Exactly. Civil courts prioritize stability for the child above almost anything else. So even if the initial arrangement was unjust or coerced, the court might rule to maintain the status quo, inadvertently giving the council's decision a kind of legitimacy after the fact. It tacitly reinforces the parallel system.
Okay, so banning these councils isn't really seen as viable, right? Because it would just drive the whole thing underground.
That's the general consensus, yes. Banning them wouldn't eliminate the demand, particularly for religious divorce. It would likely just make it harder, more expensive, and potentially more dangerous for the vulnerable women seeking help, pushing them towards unregulated hidden figures.
So if banning isn't the answer, what are the proposed solutions? How do you reconcile universal state law with this particular system operating inside it?
Well, the main legislative fix that keeps coming up, the one with broad consensus, is about marriage law itself.
Yeah.
The recommendation is to amend UK marriage law to require civil registration to happen at the same time as or before any Islamic marriage ceremony, the nikah.
So link the two. Make the religious ceremony legally dependent on the civil one.
Essentially, yes. It would mirror the system that's already in place for Church of England and Jewish weddings in the UK, where the religious officiant often acts as the civil registrar too. It creates a dual status marriage from the start.
And the benefit of that would be?
Immediate and massive. It would automatically grant women full civil protection as legal spouses from day one. They'd have guaranteed access to family courts for divorce, financial settlements, inheritance rights. It would remove that huge vulnerability we talked about.
It would make their need to appeal to the extra-legal counsels for basic financial or welfare issues much less necessary.
Precisely. It tackles a root cause of why women end up reliant on them in the first place.
Okay, that makes sense. But then there's the really thorny issue, the one that perfectly sums up this whole paradox we've been discussing, the regulation dilemma.
Yes. The big fight over whether the state should actively regulate the Sharia councils that would inevitably continue to exist, even after marriage law reform, mainly for purely religious divorce aspects.
And there are two clear sides to this argument.
Very clear sides. The majority view, coming out of official reviews, argues that some form of regulation is necessary and needed quickly.
What'd that look like?
They usually propose establishing a state-facilitated body, perhaps independent but government-backed, that would oversee a system of self-regulation for the councils. It would involve creating a mandatory code of practice.
Rules they'd have to follow.
Yes, rules requiring adherence to fundamental British legal principles. For instance, mandating that any cases involving child custody disputes or significant financial disagreements must be immediately referred to the proper family courts, not dealt with by the council. The idea is this would be a rapid way to curb the worst discrimination and protect vulnerable women right now.
Okay, that sounds practical on the surface. What's the opposing view?
The dissenting view pushes back very hard. They argue that this practical approach fundamentally misunderstands the nature of the liberal state and the principle of equality before the law.
How so?
They argue that by creating a specific state-facilitated regulation scheme just for Sharia councils, the state is effectively granting them legitimacy. It's giving them a kind of quasi-legal status they don't currently have.
So regulating them acknowledges them in a way that might be dangerous.
That's the core fear. Critics argue it contradicts the fundamental principle of one law for all. Why create a special regulatory framework using state resources and authority to oversee the application of principles like unequal inheritance or unequal divorce rights that would be illegal, even criminal, if applied by any other body to the general population? It risks perpetuating the myth that there's a separate, acceptable legal reality for one group of citizens.
Wow. Okay, that is the ultimate conflict, isn't it? It puts the state in an impossible position.
Absolutely. Do you prioritize the immediate practical protection of potentially vulnerable individuals by regulating a system, even if that system fundamentally clashes with your core values of equality? Or do you stand absolutely firm on the principle of universal civic law, one standard for everyone, even if that means, in the short term, some women might remain culturally vulnerable until broader legislative changes, like marriage law reform, fully take effect?
It forces the liberal state to really confront the limits of its own universalism.
Exactly. We've shown today that liberalism's claim to universality, well, it has its own specific, particular history, largely rooted in Christian thought.
Right.
And when it comes face to face with other powerful, deeply entrenched, particularistic frameworks, whether it's the duty-based collectivism of Confucianism we discussed, or the application of sacred law by these Sharia councils that supposedly neutral liberal framework starts to crack, it's forced to acknowledge its own particularity when it decides what it can and cannot tolerate.
So the tension isn't just theoretical, it's structural. It's happening right now. The liberal state, because it's committed to tolerance, committed to accommodating diversity, risks becoming, as some critics put it, a kind of hollow container.
Right.
Unable to actually enforce its own core principles, equality, the rule of law, individual rights, when those principles are directly challenged by alternative norms that it has allowed to operate within its own borders.
And ultimately, the policy choice here, regarding parallel systems like Sharia councils, it isn't just a simple question of how much tolerance is good. It's a fundamental political decision about where the non-negotiable lines must be drawn.
What kind of society are we willing to be?
Exactly. Liberal societies have to define what is absolutely non-negotiable to ensure that their efforts towards inclusion don't inadvertently lead to an inability to protect everyone equally under one single sovereign law.